Hello and a very warm welcome to you. This is the courthouse where we get to learn the law together. I like to remind you that it is our law class 101 because we learn the law in plain, simple and entertaining language. This week we're going to be taking a look at something that has to do with property. We're taking a look at perfection of title to land. What is perfection? These are all that you'll be finding out when we return from this break.
It's been 10 years. Yes, Law Class is 10. Thank you, our esteemed viewers, for making us your preferred station. Thank you for staying with us through the years. You are a part of our success stories. It's our festival of vibes.
You're welcome back. If you just joined us, this is the courthouse, and I'm Itohan Olomu-Agbodo. Like I told you earlier, we're going to be talking about perfection of title to land. What is perfection? What is title? And title generally means ownership to land, but you'll be learning what perfection is and how to perfect the title to your land in this episode. And I'm joined by a distinguished legal practitioner, Okungbowa. You're welcome to the courthouse.
Thanks for having me.
Okay, so what do we need to know about perfection of title to land?
Well, because of our audience, we'll try to make this as simple as possible. When you say perfection, simply means registering your title. A while ago, you mentioned that by title, we're talking about ownership. We're talking about the interest you have, with regards to a particular property. So when we say perfection of title, we're simply referring to registering the land, the property, the steps to take in registering the property with the government. Yes, when I mean government here, I mean state government. Under the Land Use Act, the governors of each state are vested with the power to hold the land in trust. But there are exceptions where there are certain areas that are also covered by the federal government. So those areas do not fall within the areas where the state governments do have control over. So if your land falls within the areas where the state government has control over, it is advised that you perfect whatever title you have. So the steps you take in carrying out this perfection is basically what we refer to as perfection of title. And it's quite a long step. The steps are quite long. I
was going to ask you that because, first of all, is it just about once money has changed hands,
Yes.
once I've paid for the property, why do I need to do any other thing further to ensure that my title is perfected?
Okay. In a country like Nigeria, where you have over 200 million, as far as some of us are concerned, and in a city like Lagos, where you have over 20 million people, the scrabble for lands is really, really, really heavy. And so there becomes a need for anybody who is able to acquire a piece of land to be able to have something, a sort of hold over the land. And one way you can have a higher hold, there's a word like that, is actually by perfecting your title. Otherwise, you may think you actually own a piece of land, and a few years later, somebody comes up with some documents saying, no, I bought this land some couple of years ago, this is the title, these are the documents, and then clash of interest comes in. And when we get to court, when it's time for
litigation,
such to be tested, the one with the legal title, which by legal title here we're referring to those properties that have actually gone through the phase of registration, of perfection. They take precedence over the ones which practically do not have any form of registration on it. So it's advisable that you perfect your title so that you can have a higher and better interest amongst other adverse persons who are actually trying to take possession of your property. And of course, it also gives the government the opportunity to also have on records those persons who have gone through the process of registering whatever they have, with them. And then again, there are some persons who want to go into business with they want to use their properties, their land, their deeds of assignments, their title deeds to get loans from banks. Most banks would definitely want to be talking to somebody who have a perfected document.
Okay, so now you've established some basic points about having a better title, because of course, like you said, we have a lot of people trying to get the same land, get hold of the same land.
Yes.
So for you to have a better title, that is what you call the legal title.
Very well.
So now we know of stamping, we know of registration. What type of stamping is required? Let us know, as in just address us like we've never heard of stamping, we've never heard of registration before. What are the steps?
Okay. In perfecting every title on any property, there are actually 3 stages. You have, if it's a property that already has a title on it before, we will have registration for the governor's consent. Now, after the governor's consent has been gotten, these are stages. Is one stage, but broken into, other stages, 3 stages, sub-stages. When you apply for the governor's consent. After the application for the governor's consent, you then have the stamping. After stamping, the last stage is basically the registration. But if you want to really go through the step-by-step processes, you begin with an application.
Okay.
Application to the land registry. Depends on what you're applying for. In your application, attached to your application will be your deeds of assignments, a survey, registered survey that has been drawn by a registered surveyor, usually 4 copies of the deeds, 4 copies of the survey. Then, and of course, several receipts of certain tax payments which the person will have to do at the land registry. Then, after that has been done, of course, the process, like I said, is quite long.
It's really long, because when we hear about land,
yes.
a lot of people are wary of the fact that they have to go through a very cumbersome process to perfect title.
Yes, usually it's just because of the country we find ourselves and the system back home. There are some countries, like in the US, in the UK, and even Dubai. The processes do not take usually between, like in Dubai, I heard that in Dubai, it's within a week, your title can be perfected. And in the UK, one is looking at between 2-3 months, So I think, personally speaking, I think it is a function of population.
Okay.
Let's come back onto Lagos, for instance. Lagos, we have over 20 million people, and we have just one small land registry that have a staff strength of, maybe perhaps less than 1,000, if I'm not mistaken. So the question is, how do these guys end up carrying out everything in front of them? During the days of Babatunde Rajifashola, he came up with a plan. He carried out some reforms at the land registry where the timelines were given to stages of perfection. In other words, if you put in your application and they say, okay, in 7 days' time, your application will be pushed to the Surveyor General's office. In 3-4 days, from the Surveyor General's office, it's pushed back to lands for assessments and all that. So they tried to stick to it, but over the years, again, we practically are back to square one. But even with all these length of time and weakness in the system, we still do advise that people should take whatever steps, whatever it will take them to perfect their title.
Well, that's quite interesting. Well, you've been listening to Louis Okungbowa, a distinguished legal practitioner based in Nigeria, and he's been talking about the steps to take to perfect the title to your land. That is to make sure that you have valid ownership of your land. We want to take a listen to this report on the steps to take, and we'll see some of our legal nuggets on all you need to know about perfection of title to land. We'll be right back. It is important for every land purchaser to understand that having a good title to land, what in layman terms is ownership of land, goes beyond merely paying money to buy a piece of land from a vendor and signing an agreement. A land purchaser is required by law to perfect the land transaction to secure its ownership rights and to avoid future risks associated with land transactions. Perfection of title to land entails stamping, registration, and obtaining the consent of the governor over the land so acquired. Under the Land Use Act, it is the consent of the governor that confers validity to the act of alienation of any interest in the land, where the land is subject to customary right of occupancy. Registration or perfection gives an indication that the land is encumbered by you, and any subsequent purchaser would be duly notified upon investigating the title at the land registry. Perfection raises presumption of land ownership in your favor against every other person who lacks a better title. Perfection passes legal estate in the land to the buyer. Where the land remains unregistered, your interest is in equity only and not legal. Non-registration renders the document inadmissible in evidence to prove your title. You may not be entitled to receive compensation from government if the land is compulsorily acquired for overriding public interest. Perfection prevents fraud and problems arising from the suppression or omission of instruments when title is deduced in case of subsequent transactions that it will show you registered interest in the said property. You're welcome back. This is still the courthouse, and we are talking about perfection of title to land. That is how to establish legal ownership of your land. It's not just about paying money or saying that this is a land handed to me by my father. There are steps that you need to take to ensure that that land is validly yours in the eyes of the law. And that's what the distinguished legal practitioner is telling us about. You mentioned the fact that we have to obtain governor's consent. You talked about stamping, you talked about registration. So are there other steps that one must take to perfect land? And
well, basically, you know, when you talk about perfection here, it depends on the kind of title you are actually applying for. Okay. There are sometimes scenarios where you can just be applying straight for a certificate of occupancy from the very beginning. But of course, if the person, your predecessor in title, the person already has certificate of occupancy, which is CFO, what you'll be applying for definitely will be governor's consent. Okay. So it then depends on what you're actually applying for.
Now, you have to make it clearer for us. You said there are different types of title.
Yes.
And you talked about predecessor in title. We don't want to go into many.
Okay, when we say predecessor in title, we're simply referring to the person who owns the property before you came to buy. Yeah, sometimes it may be a situation where you buy from a stranger. It can be anybody who actually bought the property, a vacant land usually, and then perfected his own title by then getting the C of O. Okay. But the moment a property has a C of O, the best interest somebody else will be getting, the person who is buying from the original owner, the best, whatever that person will be getting is definitely a governor's consent. Okay. Because the government would definitely not issue two C of O's for a single property.
So one property, one C of O.
One C of O. Okay. So subsequently, when you open the file, of course, you'll be able to trace the root of title. Root of title simply means your root of ownership. You know, you will see a situation where, okay, Mr. A had a C of O, handed over to B, who got governor's consent for that transaction. Of course, the governor's consent will be stamped on his deed of assignment. Okay. Person who is also buying from him too will also get same thing.
So, for clarity again,
Yes.
deed of assignment, because we try as much as possible to make everything as plain as
as
possible.
elementary, yeah.
So, deed of assignment, what does it mean? Agreement
Deed
to
of
show that
assignment,
you own the land.
Very well,
Okay.
very well.
So, right on, please.
Now, like I said, it then depends on the title. Usually, one mistake so many people do make is that they usually think that the moment they buy a property from somebody who already has a CFO, that they will apply for another CFO. So instances arise where you see people will go through the back doors out of human errors, out of corruption. You see one single property will have more than
yes,
one
because that's
CFO.
interesting, because
Yes.
now I have heard of cases where people present different...
Numerous
yes,
cases.
CFOs. You say,
Numerous cases.
this one will say, I have a better title because I have CFO, and the other party says, I actually have a CFO.
Yes.
So what happens then?
In such situations, of course, at the end of the day, everybody will still end up in court. And usually when the matter gets to court, the guys at the at the lands registry will be joined in the action. And then, of course, they will come and tell you their own part of the whole deal, and then tell the court that, sorry, okay, this person applied first, this person's own had issues. So at the end of the day, usually, the court will end up striking one of those CFOs and ranging it,
Okay.
you
So
know,
is that where
null and
we
void.
hear, I know we hear about the doctrine of first in time. When does it apply?
Very well. Doctrine of first in time is simply as the name implies, is simply who got to the lands first.
Who got the CFO
who got
first?
it. But however, there are certain circumstances where the fact that Mr. A got his title first would not translate that automatically he had a better title. Because if you dig deep to find out, you may end up discovering that some of the things he presented at the point of registration may actually not be true or correct. For instance, the question becomes, who signs the deed of assignment? Who transferred the title to him? If the person who transferred the title was not in a position to transfer, we see this happen usually in rural areas where lands that were owned by maybe family heads, and a member of the family who is not authorized to actually hold meetings or transfer property will come and say and sign the deeds. So the family head can come back tomorrow and say, sorry, this person was not in a position. So as a result of these steps that we're taking, we can fault this CFO. We've seen cases like that.
So then again, let's find out what's the difference between a CFO and a right of occupancy. CFO, certificate of occupancy.
Very well.
Right of occupancy. What are the differences?
Okay. CFO, like the name implies, is certificate of occupancy.
Okay.
It's a certificate issued to somebody who has a right of occupancy. Okay. So the governor, who holds all lands for in trust for the citizens, he issues the C of O, which is
a certificate of ownership.
Of occupancy.
Occupancy.
Yes.
Because the governor is the owner.
Not necessarily. The governor is actually not the owner of the land.
He's holding it in trust.
He holds it
because
in
it's
trust.
causing a lot of confusion
Yes.
now. Certificate of occupancy. Am I just occupying, or do I also own the land?
Well, under our Land Use Act, the best interest you have is a leasehold interest.
It's a leasehold.
And which runs for 99 years.
99 years.
So what that simply means is, if we go back to 1978 now, where the land use charge was actually came into being, from that time till now, we've not had up to 99 years, So we are still looking forward to when the first 99 years will come. But ordinarily, the way it's supposed to be done is, at the end of your 99 years, you can actually apply for an extension of your lease.
Okay. So it's quite interesting. Now we know C of O. Yes. You cannot actually say you are the owner, but you have the right of occupancy.
Yes.
You have certificates of occupancy, yes, which perfects your title to the land because you bought the land. You've gone through the steps of perfection.
Very well.
You have certificates of occupancy.
Very well.
Right of occupancy. What does that mean? Of course, there's no certificate.
Right. The right is basically the interest. The certificate is just a paper It's just like somebody who goes to school and the person is given a certificate at the end of the day. It's just the paper. But the strength of that paper is an accumulation of the rights and the powers that the person who is holding that paper and the person has. So when you say somebody has right of occupancy, it simply means it's the power that is the right, all the rights, an aggregation of all the rights that the certificate gives you. So what that means, I'm trying to look for a more simpler way to explain it. It's the certificate gives you the right to occupy the land in question.
But for the right of occupancy, you don't need governor's consent, do you?
No. When you apply for CFO, at this point, you are applying for a CFO. It is when you are transferring your title now to somebody else. Of course, any interest that has to do with land, of course, you definitely have to get the governor's consent.
Okay.
So when you're applying for the transfer, of course, that's basically where the governor's consent is needed. Of course, even the CFO, even when applying for a CFO, you cannot even, the process will still go through the governor because it is the governor that signs the CFO. So he's consenting.
What about in rural areas?
Now, in rural areas, ideally, the rights, the power to issue rights of occupancy falls on the customary leaders. But in practice, there are certain areas like Lagos State. There are practically no rural areas in Lagos State, Nigeria now. And even in some states within Nigeria, where you may have some areas that may appear rural, I can tell you in practice that the governor may have extended their powers to reach out to those places. There are several plethora of cases where people have, rural community leadership have challenged state governments, governors saying, no, we have the rights to issue on these areas. And at the end of the day, we all know how it ends up. So it's always a different ball game from what's on paper to what's in reality. Yes. But however, one thing we all should be very, very mindful of is because sometimes you see people buy property, they rush, let's quickly go and perfect, and once we've perfected it, then you go back home and sleep. Possession is also very, very key. Okay. It's not just a function of you having your certificate of occupancy, and you keep it under your locker and you save, and for 5, 6, 7, 8, 9, 10 years, you do not visit the land in question. You know, we have statute of limitation laws that limits people going to court to challenge actions that have passed certain 12 years. You know, once this action, if after 12 years you allow somebody, a squatter, for instance, to be on your property, if you have CFO, the person will come out tomorrow and plead that the action is statute barred.
It's statute barred.
And that becomes another problem on its own. It will then appear as if all the steps you took were all in vain. So it's very important that we don't just take steps to perfect our title. We must have our eyes on our property at all times. Otherwise, you just slip over your rights and all your labor will just be in vain.
Be in vain. Oh, that's quite interesting. You see why you need to consult a lawyer at all times. Louis Okungbowa has given us a very, very important advice. After you've perfected your title, don't just go and sleep in your house and say, oh, the law backs me, I have my certificate of occupancy. There's something called statute of limitation. We've treated that before. We'll be looking at it at another episode again. You need to do something. You need to, from time to time, visit your land, carry out some activities on that land. And that is an advice that came very, very, very freely. You are a first-time guest on the courthouse, so I will just do you a little intro. We have another segment where we'll talk about Latin maxims. Okay. We know lawyers like to remind us that we are phasing out Latin. We don't want Latin anymore, no verbosity, but we still like to hear some Latin and their meanings. Okay. So you've been talking about land. Give us any Latin maxim that you like. Okay.
Several. Okay, but since we are talking about land, I think the one that comes to mind should be quid platato solo sidit. What that simply means is that anything fixed on the land becomes part of the land. Okay. So if if I buy a property tomorrow that has a bungalow on top of it, there's a presumption that I'm buying everything.
You're buying everything.
If
and
I
also,
buy,
if you
I
buy
buy
your land
farmland,
and you sleep over it for more than 12 years, someone else builds land on it, goes to court, the owner, that person becomes the owner of the land.
The person can, fine, there are exceptional cases. I wouldn't want to go into the technical parts of.
So we would have to invite you again some other time.
Well, it's always definitely going to be an honor to be back.
Okay, so I'll just stick with non ex factum, which is not my deed. Non ex factum, not my deed, not my action. You get to find out more Latin maxims and their meanings in our Bar Book segment. You're welcome back, but at the same time, we have done more than we can for the weekend. This is still the courthouse. We would like to hear from you at every time. We'd like you to use our hashtags. We'd also like you to download our app, Lover Plus. We would also like to hear from you and comments, information, anything you like, questions that you want our legal practitioners to provide answers to. We would like to take them. You can send your comments to www.loverplus.tv. You can also send comments to info@loverplus.org or the number showing on your screen now. You can also use our hashtags, hashtag the courthouse, hashtag loverplus. I am Itohan Olomu-Agbodo. At this time, I want to say thank you again, Louis, for being here.
Thanks for having me.
Okay, so don't just get mad. Go get a lawyer. Bye for now.